Hi guys, and welcome back to Contract B. This is the second video for week 4, and in this video we'll be unpacking the various elements and issues in relation to the vitiating factor of duress. So here we are back at our presentation and looking at duress. You'll see there are 3 common forms of duress. Duress of person, duress of property, and the relative newcomer economic duress. Looking first at duress of person, and here we have Barton and Armstrong, and I'm sure this will be one of your memorable cases for this term. Brings a smile to my face every time I talk about it because it really does read like a bad movie script. Particularly nasty spat in relation to management of a company. You had 3 directors ganging up on a 4th director, asking him to leave, didn't want him there, didn't want him managing. He says, no, I'm not going to go. So the other 3 gang up and vote him out of his management positions on the company. Now, at this point you're thinking, oh, this poor little man, what happened? Did they bring some kind of illegitimate pressure upon him? In actual fact, the shoe was on the other foot. The director that they wanted out thought, well, if they're going to force me out, I want to be paid for it, and I want to be paid pretty handsomely. So he proposed a deed whereby the plaintiff director was to buy him out of the company. Obviously, the plaintiff didn't want to sign. The transaction did not represent a good commercial bargain for the company. The price was just way too high. And so the defendant said, well, you better sign because otherwise I'm going to have you murdered. Yes, murdered. So I wonder if the plaintiff then decided to sign. Yes, he did. And the money was transferred. The defendant walked away, or so he thought. And then the plaintiff wanted to have that transaction set aside, not surprisingly. Now, at this point in the game, you could still appeal up to the Privy Council, and that's where the matter landed. And obviously there the court said, well, if a threat to one's life is made in order to induce signature to an agreement, and the person signs, and one of the reasons for them signing was the threat that was made to their life, then obviously the court's going to give relief for the common law vitiating factor of duress. If you think back to our discussions on mistake, you would think that a common law vitiating factor like this would just render the contract void, period. However, the courts tend to treat these contracts as voidable only, which means that they remain on foot, they remain to be performed by both parties unless and until the plaintiff decides to attempt to have that contract set aside, and what the court then does is that they declare the contract void. Okay, so a little bit different to the results that you were looking at in mistake, but that's the common law vitiating factor of duress of person. Okay, the next case that you will find in the text relates to duress of property, and here we have Hawker Pacific and Helicopter Charter. Now, the defendant in this case did a paint job on a helicopter. Obviously, it was pretty bad because the plaintiff sent the helicopter back to have the paint job redone. They certainly were not satisfied with it, and they let the defendant know this.
Ain't nobody got time for that.
When they tried to pick up the helicopter, they kind of inadvertently gave the defendant a stick to beat them with, if you will, because they said, you know, come on, where's this helicopter? We need to have it for an urgent charter that we've got on foot for the following day. Now, obviously, at this point, the officer from Hawker Pacific has the little light globe go off and has an aha moment and says, well, if you need the helicopter urgently, we're happy to allow you to collect it. Just sign here. Now, the agreement that they proposed, that the plaintiffs signed, had a couple of terms of note. The first one really wasn't terribly obnoxious, just set out the agreement in relation to monies due for the paint job, no problem really. The one that caused the issue was that the defendant wanted the plaintiff to release them for any and all liability for defective work on the paint. So the defendant didn't want that helicopter back again. They didn't want to have to fix anything else up. They didn't want to know these people. They wanted their money and they wanted to part ways. That was it.
Go away, go away.
Now, obviously, because the helicopter was required urgently the next day, the officer from Helicopter Charter kind of went, what option do I have? I have to have this helicopter. And so they signed on the dotted line. Obviously, there were further problems with the paint down the track, and they wanted to have the transaction set aside for the vitiating factor of common law duress of goods. Now, the court has a little look at the issue of duress of goods in this case, and they look at the issue of perhaps the more extortionate situation where you have one party illegitimately withholding the other party's goods and saying, well, hey, here they are. If you want them back, you're going to have to pay us for them. Here we have one party illegitimately withholding the other party's goods, and instead of saying just pay us money, what they are saying is sign on the dotted line. Please enter this contract and then we'll give your goods back to you. So there was not a whole lot of a leap to move from providing relief for extortionate threats to get money and to hear the issue of extortionate threats to procure execution of a contract. Contract was avoidable for duress. So that is duress of goods. No real surprises, slightly entertaining fact situation there. Then we have economic duress. Now, economic duress is kind of the new kid on the block, and the big case here that you'll need to read from the textbook and also the extract in the case book is the North Ocean case. A little bit of a complicated fact scenario, so I'll run it through with you. Some of these facts are in your books, some are directly from the decision itself here, so it might kind of elucidate your understanding a bit after we've had a chat about it here. We had North Ocean engaging Hyundai to build a rather large tanker for them, and the contract stipulated that the payments were to be made in US dollars. There were to be 5 payments, all in US dollars. In return, Hyundai provided what we call a reverse letter of credit. And what that was essentially a promise or a letter stating that Hyundai would credit back North Ocean Shipping all of its instalments if Hyundai defaulted on its performance of the agreement. Now, after the first payment was made, unfortunately for Hyundai, the US dollar dipped by about 10%, and the people at Hyundai were obviously pulling their hair out. All of a sudden, they're going to get about $3 million less on this contract. So what they ingeniously do is simply say, well, look, you've paid your first instalment, but from now on, from this point in time onwards, all of the other instalments we want you to pay at an increased amount of 10%. That would obviously offset the problem with the US dollar that had occurred in its devaluation. Now, North Ocean Shipping, again, a little bit like the helicopter charter case, really don't have a whole lot of choice in this matter, do they? It's a very large tanker. They needed it for a contract that they had to perform with the Shell company. That was going to be a very lucrative contract for them. So they didn't tell that, though, to Hyundai. Thankfully, otherwise perhaps Hyundai would have jacked the price up even more. That's what the court thought. So North Ocean says that they will agree, one, basically, so that the parties could stay friends, and two, they said that they were going to pay the instalments without prejudice to their rights. That is, they reserved their rights. So that communicated to Hyundai that yes, Hyundai would be getting its money, its increased amount of money as they wanted, but that North Ocean felt free to later on dispute that payment. Now, in return for the increased instalment figure, interestingly, Hyundai increased their reverse letter of credit back to North Ocean Shipping in the same amount, okay? Now, there was some dispute here about whether or not a contract to vary the terms of the original contract had been agreed at this point. And the issue that the judges kind of got stuck on was whether or not Hyundai actually did provide consideration in return for North Ocean actually agreeing to that increased figure. And the judges settled on the fact that yes, Hyundai's increased amount in its letter of credit effectively concluded a contract to vary the terms of the original contract. And so then the question was that contract concluded under a situation of duress? So the court has a little look at the circumstances surrounding the case. There was no legal justification for Hyundai asking for that extra 10%. The only practical justification was, as I said, they were going to make about $3 million less on the deal if they didn't do this. Both parties knew that Hyundai wouldn't accept anything less than full agreement to their request for that extra 10%. As I said, North Ocean did not tell Hyundai about that lucrative contract with Shell. So I guess Hyundai didn't have that extra leverage point that was apparent in the helicopter charter case. There was some debate about the nature of the delay surrounding the final payment of the final instalment by North Ocean to Hyundai. What had happened was they had contracted Hyundai to build this ship, which was called the Atlantic Baron, and then they subsequently contracted Hyundai to build another tanker called the Atlantic Baroness. Now, there was some discussion about whether or not they could do anything about this demand for the extra 10%, given that A, they needed the Atlantic Baron for the Shell contract, and B, they wanted the Atlantic Baroness. Now, the court had a bit of a fossick around in the facts here as to what exactly North Ocean believed would happen if they made some kind of protest around the time of making the final payment. And they found that North Ocean didn't really believe that if they had protested that the tanker, the Atlantic Baron, would be withheld from them. And they also didn't really think that it would prejudice the deal in relation to the Atlantic Baroness. So at the time when they made the final payment, they really needed to express once again the fact that they were making this payment without prejudice to their rights. That is, communicating to the other party regularly and often that they would make the payment, but they felt free to dispute it afterwards. The court found that North Ocean was effectively freed from its duress in around November 1974, once they had delivery of the Atlantic Baron. But the problem was it had taken them from November 1974 to July 1975 to actually raise the issue and bring the current arbitration forward. And critically, the court said, in commercial situations like this, sorry, that delay constitutes your affirmation that you are willing to accept the contract that had been executed between the parties to vary the original contract, and accordingly, North Ocean couldn't actually have the extra payments set aside. They couldn't have that additional contract set aside. So very important consequence, as I averted to earlier on in this video, of the contract being voidable and not void. Okay, you can't sit on your rights, particularly where you've got two very well advised, very savvy, very experienced commercial parties that had dealt with each other before. You cannot afford to sit around and not pursue your rights in a very timely fashion. Obviously, like I said, where you have commercial circumstances, what is going to be considered timely will be probably a shorter period than perhaps it would otherwise be. So that is the North Ocean shipping case. Remedies, well, obviously, if you're going to elect that the contract be voided, essentially what you're asking the court to confirm is that you have rescinded the contract. The text also goes through some other alternative remedies, possibility of restitution, possibility of damages, probably using the tortious measure there. Section 50 sub 1 of the Australian Consumer Law also contains a prohibition on physical force and undue harassment or coercion, which effectively equates to common law duress. Subsections A through B relate to the supply or payment for goods or services, and subsections C through D relate to the sale or payment for land. Now, the beauty of those particular provisions is that once you tap into those and the court finds that there has been physical force or undue harassment or coercion, then that unlocks the goodie bag of remedies that you can get in the ACL, including damages under Section 236 and those various flexible orders, variation, part rescission, all sorts of things in Section 237. So they are the remedies for duress. That is the common law vitiating factor of duress. So I'll end this video here. It's a relatively good place to break, and we can come back for part 3, and that will be undue influence. Thanks, guys.